Hi everybody, Phil Snyder, GunClassUtah.com. Hey, today we are going to go over some of the sections in the Utah Criminal Code. I'm a Utah licensed concealed firearms instructor with the state of Utah. I'm also a retired law enforcement officer with 30 years of experience and training. But what we're going to do is we're just going to go through all of the criminal code that is part of your minimum training curriculum in order to get your Utah concealed firearms permit. And so all of this stuff and these codes can be found in your Utah minimum training curriculum. If you have a copy of that, some of the sections, they have moved them to another chapter. And so that might seem a little bit confusing, but anyway, let's get started on that, shall we? This first section is Utah use of force in defense of persons and property and real property. First of all, let's start out with this particular title right here, 76-2-401, justification as justification as a defense and when it's allowed. As we go through the use of force statutes, you're going to see words like you are justified when these conditions meet in a self-defense situation. Okay? Just because something says that you're justified under the law when they're not really giving you permission to use force. They're just providing you a defense. Okay? So, conduct which is justified is a defense to prosecution for any offense based on the conduct. The defense of justification may be claimed, A, when the actor's conduct is in defense of persons or property, and we're going to talk about those sections in a minute, when the actor's conduct is reasonable and in fulfillment of his duties as a governmental officer or employee, such as a law enforcement officer. C, when the actor's conduct is reasonable discipline of minors by parents, guardians, teachers, or other persons in loco parentis. So they're talking about parents' right to discipline and caretakers of children, things like that, school teachers. When the actor's conduct is reasonable discipline of persons in custody, so they're talking about corrections officers and the performance of their duties. E, when the actor's conduct is justified for any other reason under the laws of the state. Lastly, paragraph 2, the defense of justification under 1C is not available if the offense charge involves causing serious bodily injury. Okay. We're going to talk about serious bodily injury definitions a little bit later. But basically, if you cause serious bodily injury, and this applies to parents disciplining their child, that would be seen as not acceptable because it's a serious injury, and the state does not allow you to do that with your children under reasonable discipline and management of a child. Force in defense of a person and forcible felonies defined. As used in this section, the following are forcible felonies: aggravated assault, mayhem, aggravated murder, manslaughter, kidnapping, aggravated kidnapping, rape, forcible sodomy, rape of a child, object rape of a child, sexual abuse of a child, aggravated sexual abuse of a child, aggravated sexual assault, arson, robbery, and burglary. Forcible felony includes any other felony offense that's not listed that poses a risk, a substantial danger of death or serious bodily injury. C, the legislature wants to make it clear that forcible felony does not include burglary of a vehicle unless it is occupied at the time the unlawful entry was made or attempted. 2A and 2B, this is your justification to use force in self-defense. An individual is justified in threatening or using force against another individual when and to the extent that the individual reasonably believes that force or a threat of force is necessary to defend the individual or another individual against the imminent use of unlawful force. So, in order order for you to use force against somebody else's use of force that's unlawful against you, or an unlawful threat made against you, uh, number one, their threat or their use of force has to be unlawful, and it has to be an immediate threat to you. So this is occurring right now, or they're up in your face. This is about to happen. And your force, when you're defending yourself and other people, has to be a reasonable response to what their threat or what their use of force is. And a reasonable person would be somebody like a juror that's asked to decide your case in a jury trial. A juror that's selected by the attorneys, the prosecutor and defense, would be considered to be a reasonable person. And what they do in court is they will ask a juror to be placed in your shoes, and they give all the facts to the juror, that everything that you knew at the time that this threat or this use of force that was unlawful being used against you, and they're asked to consider whether that is reasonable or not. To be here, this is the justification to use or threaten to use deadly force in protecting others. Notice this chapter here talks about you can defend yourself and other individuals. And so this is not limited to you and your family, but it could be anybody. Even though the law does not obligate you to do such a thing, to protect other people, it's something that you can do under the law, as long as your force is reasonable. But in the state of Utah, you can only use deadly force, and deadly force is defined as any force that's intended or likely to cause serious bodily injury or death. Number one, you are in imminent fear of that person's threat or unlawful force that's going to cause either serious bodily injury to you or death, or the other circumstance is if you are using that force to prevent the commission of any of the forcible felonies that we mentioned above. Paragraph 3 is talking about conditions to where you're not going to be found justified if these circumstances are discovered during an investigation. If you initially provoke the encounter against the individual with intent to use force as an excuse to inflict bodily harm, so in other words, you initially provoked it. 2, if you're involved in felony crime when this force is being used, you can't claim self-defense. For example, there was a drug dealer in Tooele about a year or two ago. He was dealing THC vape cartridges, which is a felony, and he met up with these 2 juveniles in a parking lot. And they robbed him at gunpoint of the drugs, and the drug dealer drew a weapon and fired it and killed one of the persons robbing him. Well, when the police showed up, they arrested the drug dealer that had the gun stuck in his face that was being robbed, and he was quite surprised to learn that he did not have a defense for self-defense because he was involved in the felony commission of a crime. Last one says if they clearly and effectively retreat. Okay, so let's say somebody initially starts a confrontation with you. Let's say that they, shove you to the ground, and you get up and, you start throwing punches with them, and then they hold up their hands and they say, okay, stop, I've had enough. If they've clearly and effectively communicated that to you, then you are no longer justified for any force that you use after that point. Paragraph 4 says that there is no duty to retreat as long as you have entered and remained and you're in a place that you have a lawful right to be. There's no obligation under the law to retreat from the danger. And failure to retreat, even though you could have done so, could not be used as evidence against you in a criminal trial. Now, I would say if it was feasible for me and if it was something that I could easily retreat from, did not endanger myself to do so, I would do it. But that's just me. When the trier of fact is looking at the circumstances in a use of force case, and use of force cases in Salt Lake County are always particularly deadly force situations, they are reviewed by the district attorney's office from a referral from law enforcement, and they review all deadly force shootings. But the prosecutors and the trier of facts are going to look at the following factors to determine if your force was reasonable or not. The nature of the danger, the immediacy of the danger. Remember, it has to be an immediate threat to you. The probability that unlawful force would result in death or serious bodily injury. So the more serious the case and the more likelihood that there's death or serious bodily injury involved, that is going to be given some weight in determining your reasonableness. The other individual's prior violent acts or violent propensities. Did they do things, and was their behavior indicating that they were a violent person? Did you know that they had a history of being violent? Were the acts that they were doing giving you an indication of that? Or any patterns of abuse or violence in the parties' relationship, and any other relevant factors? I would say at the top of the list should be minding your own business. As a 30-year law enforcement officer, and I've worked in patrol for about 17 years, I saw a lot of people that weren't minding their own business that got themselves into a lot of trouble for things that they could have easily avoided. Another situation is, let me use a road rage, for example. Two people are involved in a road rage situation, and maybe somebody brandishes a gun to the other driver, and then they drive away, and the victim of the brandishing decides to chase them down. Now those roles are kind of reversed, and that person is pursuing that other person and maybe doing some foolish things when that danger is over with. And now maybe both of these persons get charged. So just something to consider. Here's a new one this year. Force and arrest or temporary detention. A person is justified in using any force except deadly force when the person reasonably believes to be necessary to effect an arrest or temporary detention, or to defend the person's self or another from bodily harm while making an arrest or temporary detention. Force or deadly force in defense of habitation, vehicle, or place of business or employment. Notice this was changed May 1st of last year. Prior to this change, it was 1985. And basically what they've done, they have included, it used to be just the defense of habitation, but now they have added and included under this chapter the vehicles, the place of business, and the places of employment, and now these are extensions to your home. So as we go through and read this chapter, I'm just going to summarize it for you, and I really encourage that you read these use of force chapters in the entirety, word for word. But as we go through this chapter, just keep in mind that they're also talking about the vehicles and the place of business and the place of employment. So basically what it says is, it says that you are justified in using force against an individual that you reasonably believe is necessary to prevent or terminate another individual's unlawful entry into one of these areas, or to prevent an unlawful attack upon these areas as well. Paragraph 2 is talking about the justification to use deadly force to prevent or terminate unlawful entry or attack on these areas. It requires entry to be made in a certain way. It says an actor is justified in using force against the individual described in subsection 1 that is intended or likely to cause death or serious bodily injury. Another word for that is deadly force. Only if the entry is made or attempted in a violent, tumultuous manner. So let's say that somebody beats in your door and comes in with baseball bats, like what happened to Leon Peterson back in the early 90s. He was going through a divorce with his wife, and he had temporary custody of their daughter that was very young. And his wife was a manager at the Red Lobster over there in Sugar House, and she hired some Polynesian gang members that were employees of the restaurant to go do a burglary of the home, and she told them that there was a gun collection in the home and that they could have those, and she gave instruction that she wanted her daughter back and just to make it look like a burglary. Well, Leon was asleep and he got a knock at the door or a doorbell ring, whatever it was, and he grabbed his 9mm Beretta and he racks around in the chamber. And as he goes downstairs to investigate who's at the door, the knock at the door was at the carport. And at this time, he thought that it was his elderly neighbor that was maybe locked out of her house. And so he let his guard down a little bit and he undid the chain on the door, and then they kicked the door in and they were swinging baseball bats at him. And he just emptied his magazine into this first guy coming through the door, and the others ran off. Well, there was a trial on it. Leon was obviously acquitted, and this was ruled self-defense, and his wife was charged with conspiracy to commit murder and some other charges, and she was sentenced to prison. So either that violent, tumultuous entry, surreptitiously or by stealth. Surreptitiously would be, an example. Maybe somebody knocked on the door and they said delivery driver, and they tricked you into opening the door and they came in under some sort of a trickery. Or, stealthy entry would be somebody, sneaking in through a window or picking a lock, something like that. But anyway, if entry is made or attempted in one of these manners, and it also says that you must reasonably believe that the purpose of their entry or attempted entry is to perpetrate personal violence against somebody that's in the home, or worse. So if you were in fear of your life when somebody kicked in the door, as I'm sure Leon was, that would be some justification to do that. Under paragraph B, it says, or you reasonably believe that the entry is made or attempted for the purpose of committing a felony in the home, and the force is necessary to prevent the commission of the felony. So, for example, let's say that you hear a noise in your basement at 2 o'clock in the morning, and you grab your gun and you go downstairs to see if it's just the cat knocked something over, or maybe somebody's in the home, and you see some stranger in your home that's unlawfully there, and they were walking to your child's bedroom down the hall. Well, I think a reasonable person would conclude that their children might be in danger of being kidnapped or harmed or something like that, which would be a felony. And so that would be another example of that. Paragraph 3A. This is the legal presumptions of reasonableness under this statute. Okay? The first one says, the actor who uses force or the deadly force against an individual to defend their habitation is presumed for the purposes of criminal and civil cases to have acted reasonably if you use that deadly force in the manner that we just talked about earlier in the video under here. So you either had that violent, tumultuous entry or a surreptitiously or stealthy entry, and you had that reasonable belief that there was going to be personal violence, or you had a reasonable belief that they were in the home to commit a felony. The presumption of reasonableness is there for you. The presumption of reasonableness to defend the vehicle, the place of business, or the place of employment for purposes of civil and criminal cases is, if you use the deadly force in the manner that you were instructed to do, as we talked about earlier in this chapter, and the person entered or attempted to enter unlawfully and with force the vehicle, the business, or the employment, or they removed or attempted to remove unlawfully and with force the actor from the actor's vehicle or place of business of employment, and very importantly, you did not provoke the individual, and you were not otherwise engaged in criminal activity other than a traffic offense. at the time the force was used. The presumption in subsection 3b applies to the actor's use of force or deadly force against an individual to protect a third person only if the circumstances are present to where you reasonably believe that immediate intervention is necessary to protect third parties. Force in defense of property. Okay, they're not talking about your habitation here. They're not talking about your habitation, but they're talking about things that can be replaced. For example, they're talking about maybe an unoccupied vehicle burglary where nobody's in the car and somebody's just trying to steal items out of the car, or they're trying to steal a car that's nobody's in. Or maybe, vandalism. Somebody's vandalizing your property, or somebody's stealing maybe a bicycle out of the yard or something like that. So they did change the law this year, and I'll talk about what it is here in a minute. But you can use force other than deadly force to protect your things if you reasonably believe that using the force is necessary to prevent or terminate criminal interference with your property. If the real or personal property is lawfully in your possession or lawfully in the possession of your immediate family, or if you're a security guard under C, or you're some person that has a duty to protect property, and police officers as well. D, they added this year, last month. Now, you can also defend personal property that you reasonably believe belongs to another person and that the individual's criminal interference is meant to deprive the other person of the personal property. And determining reasonableness, the apparent or perceived extent of the damage or the theft to the property is going to be taken into consideration. Anyone that has previously damaged your property, or any threats of personal injury or damage to the property that have been made previously by the individual. So what they're saying is if there is a history of somebody that's damaged your property, or if there is some prior threats that were made, or any patterns of abuse or violence between the actor and the individual, these are going to be taken into consideration of reasonableness. So when you're protecting property, you just have to ask yourself, is it worth it? Because usually things can be written off on insurance. They can be replaced. There was a case out in Ogden just about 6 months ago. A man found somebody midnight breaking into his vehicle. They were inside, and it looked like that they were taking some things. And when he confronted this guy, the suspect fled on foot, and the vehicle owner chased him on foot, not knowing if he had taken anything or not. Well, they ended up in a church parking lot, and the suspect turned around and they stabbed him with a knife. Now, I don't know if this guy would do this all over again, but you certainly have danger when you're protecting property, and so you could even be killed. You don't know if they have a gun on them. You don't know if they have a knife. And so you just have to ask yourself if it's worth it or not. Me personally, it's not. Force in defense of individuals on real property. So real property, for an example, would be my home and the lot that it sits on. Real estate, land that you owned. Maybe you've got some property, a cabin up by Strawberry Reservoir. That's what they're talking about here. I think that this is extremely rare. As a law enforcement officer and 18 years working patrol, I've never seen a use of deadly force for trespassers coming onto the property. Just need to make sure that you've got all the elements here. It says an actor is justified in using deadly force against an individual that's trespassing onto real property only if you're in lawful possession of the real property. You also must reasonably believe that deadly force is necessary to prevent or terminate the individual's trespass onto the real property. The individual's trespass is made or attempted by use of force or in a violent, tumultuous manner, and one of these under D. You either reasonably believe that the trespass is attempted or made for the purpose of committing violence against an individual on the real property, and that the force is necessary to prevent personal violence, or you reasonably believe that the trespass is made or attempted for the purpose of committing a forcible felony that poses imminent peril of death or serious bodily injury to an individual on the real property, and the force is necessary to prevent the commission of the forcible felony. The presumption of reasonableness is if you use the deadly force under the conditions that we just described for purposes of civil and criminal cases, that you acted reasonable. Now, just because there's a presumption of reasonableness does not mean that you are off the hook from civil and criminal penalties. Okay? This is just providing you a defense, as I said earlier. Just because somebody says that you're justified in doing something, that will be determined by a court of law if a prosecutor decides that your actions were not reasonable, or that your actions were not reasonable, or presumptions can always be rebutted. There could be witnesses that could contradict your statement to officers. The suspect that came onto your property could contradict what you said. But this is just saying, there is a presumption of reasonableness for civil and criminal cases if these were the facts that were known at the time. Something to consider. Whenever you are using force in self-defense, you always have the risk of not only, as we all know, being criminally charged if a prosecutor says that your actions were not self-defense, but you also have civil liability as well. You could also be civilly sued if your actions, in the opinion of the trier of fact, are not reasonable. So let's look at O.J. Simpson. A lot of you that are older are aware of O.J. Simpson. He was a retired NFL football player. He murdered his wife in California. I think they were going through a divorce, and she had a friend. They were both murdered. O.J. Simpson was charged, and he went to a criminal trial. And the standard of proof in a criminal proceeding is beyond a reasonable doubt, which is the highest standard of proof. Well, the gloves came out that were picked up in evidence, and they didn't fit O.J. Simpson's hands, which he tried to put on in front of a jury. And that created reasonable doubt enough that he was acquitted. And a lot of people were upset over that because they believed that he did murder his wife. But the family sued a civil case, a wrongful death lawsuit against O.J. Simpson, and a civil trial. And the standard of proof in a civil trial is beyond a reasonable doubt. The standard in a civil trial is the preponderance of the evidence, which means the weight of the evidence. Imagine a set of scales here of justice, and if the plaintiff who is suing the defendant, O.J., the plaintiff can just put on enough facts that are going to tip those scales of justice into that party's favor, they're supposed to win the case. So you just need to keep that in mind whenever you're in a situation when you're using force. You've got the risk of being named in a lawsuit for both of those. Fortunately, under the laws of the state of Utah, we've got a little bit of insulation from civil and criminal liability here. Defense to civil action for damages resulting from commission of a crime. So it says a suspect, for example, may not recover from the victim of a crime for personal injury or property damage if the person or the suspect in this case entered the property of the victim or the victim's family with criminal intent, and the injury or damage was inflicted by the victim or occurred while the person was on the victim's property, or the person committed a crime against the victim or the victim's family during which the damage or injury occurred. These provisions do not apply if the person or the suspect can prove by clear and convincing evidence that the person's actions did not constitute a crime against you. This section also applies to any next of kin, heirs, or personal representatives of the person if the person acquires a disability or is killed. So this also applies to family members of the person that you harmed in a self-defense case, or attorneys and things like that. However, this does not apply if the person committing or attempting to commit the crime against you or your family clearly retreated from the criminal activity, or they can show that their actions did not constitute a crime. Clearly retreated means that the person committing the criminal act has fully, clearly, and immediately ceased all hostile, threatening, violent, or criminal behavior or activity. Here's another one. This is perhaps my favorite that insulates us a little bit. Justified use of force, also known as a justification hearing or a self-defense hearing. So in 2021, the Utah legislature passed this law, and only Florida and Utah, to my knowledge at this time, have this privilege. And what it says is, if you are in a situation to where you're being looking at being criminally charged by a prosecutor, and they want to make your life miserable and pursue you in a self-defense case for manslaughter or something like that, or maybe there's an assault and you injured somebody in self-defense. As long as it is a Class A misdemeanor or a felony that they are charging you with, you have the right. Your attorney would represent you in this. You would definitely want to get an attorney. And by filing a motion through the court, there could be a hearing in front of a judge. And so this is just a hearing on your use of force and determining if you were acting within the bounds of the law. And it's the prosecutor's burden to show with clear and convincing evidence to the judge that your actions were not in self-defense. If your attorney can show to the judge that your actions were within the law and the judge rules that this was self-defense, now the prosecutor has to dismiss your charges with prejudice, which means he can't just refile it later, given just exactly the way it stands. So that is another good law that helps us out a little bit. You do not have the right to have a self-defense hearing if it involves a law enforcement officer or if this is a crime of domestic violence that you're charged with. It also says that your attorney can bring up a self-defense hearing in front of a jury trial, but the prosecutor cannot do so. But that could be something that your defense attorney could bring up if he felt like that was relevant in your situation. But all throughout the use of force chapters, we've been talking about force that's intended or likely to cause serious bodily injury or death. So let's go over some definitions now. Bodily injury under paragraph 4 just means physical pain, illness, or any impairment of a physical condition. Dangerous weapon means any item capable of causing death or serious bodily injury. So a gun or a knife or a baseball bat or a pen, I suppose, if you stabbed him in a major artery. Also, if we scroll down here, we're going to take a look at what the definitions of serious bodily injury and substantial bodily injury are. Right here under paragraph 17. Serious bodily injury means any bodily injury that creates or causes serious permanent disfigurement, protracted loss, or impairment of the function of any bodily member or organ, or creates a substantial risk of death. So serious bodily injury, force that is intended or likely to cause serious bodily injury or death, would be one of those that would be justification to use deadly force when you have a threat of an immediate unlawful threat of serious bodily injury or death. Substantial bodily injury means bodily injury not amounting to serious bodily injury that creates or causes protracted physical pain, temporary disfigurement, or temporary loss or impairment of the function of any bodily member or organ. Let's get into all of the assaults, aggravated assaults, misdemeanor assaults, and other unlawful uses of force here. The definition of an assault under paragraph 2, an actor commits assault if the actor makes an attempt with unlawful force or violence to do bodily injury to an individual. So an attempt, let's say that I took a swing at you and I missed because you ducked out of the way. That was still an attempt to do bodily injury. Or they commit an act with unlawful force or violence that causes bodily injury. So in this case, if I punch you in the face and actually connect that punch, that would be the act. Or they create a substantial risk of bodily injury. Movie I think it was Big Daddy with Adam Sandler, a movie back in the 90s, I believe it was. Do you remember when he had that young boy and he was mentoring this boy supposedly, and he was taking care of him for a little while, and they went out to this park, and there were these people, skating, roller skating or roller blading, whatever it was, and he was trying to, be funny in front of the kid, and he said, "Watch this. I like to do this." And he throws that stick out in front of in the path of these people that are on the rollerblades. And this guy on the rollerblade had to maneuver around it, and he almost fell down because of this stick being thrown out in front of him. That would be some unlawful act that would create a risk of bodily injury. That's just an example of what that means. So assaults, the way that we just described it, assaults that involved bodily injury under those definitions previously, that would be a Class B misdemeanor. Misdemeanors, the most serious of the misdemeanor would be the Class A, just under the felonies, and the B would be in the middle, which is what simple assaults are that involve bodily injury. And then Class C misdemeanors are the least serious of the misdemeanors. An assault becomes a Class A misdemeanor if the actor causes substantial bodily injury to the individual, or if you assault a woman that is pregnant and you have knowledge of the pregnancy, that would be a Class A misdemeanor. Assault or threat of violence against a school employee. Okay? They make these charges 1 degree higher in severity, and it's a little bit more serious if this assault or threat of violence is against a school employee. And so if the person that he assaults or commits the threat of violence against a school employee, this can be either a school employee, like a teacher, for example, in a public or a private school. The actor must know that they are a school employee, and when the employee is acting within the scope of their duties as that school employee. So that that teacher or other employee would actually have to be working at the school and not just off for the summer, and or the teacher is maybe not working during hours. They would actually have to be on duty working as a teacher. They have knowledge of that teacher's position in order for that to be assault on a school employee. Assault against a peace officer or a military service member in uniform. Similarly, as the school employee, if they know that they are a law enforcement officer, they are in the performance of their duties, that would make that a Class A misdemeanor, which is 1 degree higher. And it would be a 2nd degree felony if a dangerous weapon or other force intended or likely to produce death or serious bodily injury was involved. Assault or threat of violence against a healthcare provider, emergency medical service worker, or health facility employee, owner, or contractor. So similarly as the teachers and those military service members and peace officers, this also extends to healthcare providers or EMTs and things like that, paramedics. Propelling a bodily substance or material. Bodily substance includes saliva, blood, urine, semen, or fecal material. Okay, it's a Class B misdemeanor to propel one of these objects at a person. It becomes a Class A misdemeanor if that person that propelled that bodily substance on you had HIV, hepatitis B, or hepatitis C, or that substance came into contact with the face, including the eyes or the mouth, or comes into contact with any open wound on the individual's body. When I was a police officer working up in Mill Creek, I had a prisoner in custody, and he was drunk, and I was seatbelting him in the car, and he spat in my face. At the time, they didn't have these laws out here, and so now they've defined this. But this is considered a use of force. So Class A misdemeanor, it could be as serious as that, and they start out at Class Bs, depending on whether they do that in the face or not, or whether they actually have some sort of a communicable disease. Aggravated assault. When we talked about defensive persons, aggravated assault was in the category of the forcible felonies. If you notice here, aggravated assault has very similar elements to basic assault, right? It's shown right here. The actor attempts with unlawful force to do bodily injury, or they make a threat accompanied by a show of immediate force to do bodily injury, which is different. The assault didn't have this actually in the statute, but in this case, the actor says, "I'm going to kick your ass," and they double up a fist. That would be making a threat accompanied by a show of force. The actor commits an act with unlawful force or violence that either causes bodily injury or creates a substantial risk. Sounds like assault, right? However, in order for it to be an aggravated assault under this statute, it must include the use of either a dangerous weapon or a motor vehicle. Apparently, there's been enough people trying to use their vehicles to run people over and assault them, and so the legislature has made it very clear that, if you try to strike somebody with your vehicle with intention to cause bodily injury or worse, then that is a aggravated assault. Or choke holds and strangulation under this one. Any act that intentionally or knowingly impedes the breathing or the circulation of blood of another individual by the use of the unlawful force, by applying pressure to the neck or throat of the individual, or obstructing the nose, mouth, or airway, or any means or force likely to produce death or serious bodily injury. That would be the definition of aggravated assault. I thought I'd throw this one in here since nobody seems to know what mayhem is in my classes. The actor commits mayhem if the actor unlawfully and intentionally deprives an individual of a member of the individual's body. So, for example, out in Tooele at the Country Fan Festival, somebody's finger got bit off during an attack. Disables or renders useless a member of the individual's body, cuts out or disables a tongue, puts out an individual's eye, or slits an individual's nose, ear, or lip. Yuck. Commits a threat of violence if the actor threatens to commit any sexual offense against an individual, or they threaten to commit they threaten to commit a bodily injury offense, death, or substantial property damage, and they acted with intent to place an individual in fear of one of those acts being committed against you. Or they make a threat accompanied by a show of immediate force or violence to do bodily injury to an individual. threat of violence would be a Class B misdemeanor. It's not a defense under this section that the actor did not intend to carry out the threat just because they made that threat, and if they can show intention that they were trying to cause you to be in fear of that being committed, that would be a threat of violence. Okay, this concludes our use of force video for your Utah Concealed Firearms Permit course. I hope this was helpful for you. You've got a 2025 update. I've got you current all the way through this year. A number of these laws that you can see when we did the review have been changed to some degree. May 2025. So if you know anybody that has not taken a Utah concealed carry class for a while, please like and share this video, and let's get the word out. Some good videos for some good knowledge, and please pass it on to them. Be a good refresher for them. Thanks for watching.